Hello, everyone, and welcome to this month's webinar, Ask an Attorney, Creating Equality in Today's Workplace webinar session. The specially formatted free webinar is available exclusively for our customers enrolled in our subscription services. I'm Stephanie Blicky, the Corporate Accounts Executive for Personnel Concepts, and I'm joined by my co-moderator, Leon Firestone, who serves as our Senior Regulatory Researcher.
Hello and good afternoon to all of our attendees. And for today's webinar, we will be discussing a few key workplace equality topics that are particularly relevant in 2022. We will review recently enacted equal employment laws and best tips for creating a work environment that is free from discrimination. And after a brief lesson, you'll have the opportunity to consult with our attorney on workplace equality issues in our live Q&A session.
That's right. So today's agenda will consist of an introduction of our guest attorney. At that time, he will provide us with an overview of the most pressing workplace equality topics in 2022. Next, our guest attorney will accept questions and answer them live, providing our beloved Personnel Concepts customers with the invaluable experience of engaging with a knowledgeable attorney on the most critical employment law and equal employment opportunity topics affecting employers in 2022. Before we leave, we'll provide some key takeaways from today's session, and throughout we'll be engaging the audience with some poll questions.
Yes, and speaking of engagement, let's get started with our first poll. Today's webinar session is heavily dependent on audience participation. And to make the best use of our time, we're in search of timely and meaningful equal employment opportunity questions to present to our subject matter experts. So to ensure that we are prepared to fulfill today's hour with helpful content, we need to know the following. And I'm going to pull up the poll now. And what we need to know from you all, heading into the session, is: do you have a question or questions prepared for today's Creating Equality in Today's Workplace Q&A session? You're going to choose all that apply. Is it yes, you have a question and you submitted it during the registration process? Yes, you have a question that you are prepared to submit in the GoToWebinar chat feature. Is it yes, and you'd like to join the broadcast and ask your question live? We'll do our best to accommodate that. Or is it no, I may ask a question based on the presentation? Or is it no, I don't need any complimentary workplace equality advice? We'll give everyone a chance to submit here. We are still collecting responses. Everyone go ahead and answer. I know a few of you guys did submit during the registration process, so make sure you are selecting accordingly. And we'll go ahead and close that now. And based on the results, it looks like about 12% of you did submit a question during the registration process. Almost 80% of you say you may have a question based on the presentation today. So we'll do our best to get you out as much information, and that way you'll have a question to ask. Thank you for your participation.
All right, yeah, thanks to our audience. So as your Q&A session moderator, I'll be directing your submitted questions to our guest attorney. Keep in mind your question may be slightly modified to ensure the best outcome for this session. The purpose of this webinar is to provide accurate and authoritative information on the subject matter being discussed. It does not constitute legal advice. The applicability of the tips and laws discussed today may depend on your state, type of business, and number of employees. We recommend working directly with legal counsel and your human resources professionals on specific matters pertaining to your business. Personnel Concepts, our webinar host, and our guest speaker are not liable for any errors, omissions, or changes in law that lead or advice that leads to unfavorable outcomes.
And then on today's webinar, we're hosting a special guest attorney panelist to deliver guidance on the topic and answer questions in today's Q&A session. Our panelist has frequently been featured as a guest speaker in our webinars, and I'd like to welcome back Jeffrey Fucci, the attorney that's going to be consulting with you guys today. He's a graduate from Vermont Law School with a dual master's degree in JD and serves as in-house legal counsel to a diverse group of corporate clients. Jeff provides counsel to his business clients on matters including labor disputes, employment negotiations, anti-discrimination, workplace policies, equity agreements, non-disclosure agreements, and general consultation. Today, Jeff will cover several workplace equality topics, including employment discrimination on the basis of sexual orientation and gender identity, gender equality and the wage gap, and the ADA reasonable accommodations regarding long COVID.
Thank you for that introduction, and thanks for having me, Leon and Stephanie. Let's begin with addressing one of the newest developments regarding sexual orientation and gender identity in the workplace. At the top of the most recent news are sweeping internal changes to how the Equal Employment Opportunity Commission, which is the federal EEOC, handles discrimination complaints and other reporting by making internal changes that now give individuals the opportunity to select a non-binary X gender marker during the self-identification questions that are a crucial process during intake when employees are filing a charge of discrimination. The EEOC has announced that the former binary construction of male and female does not reflect the full range of gender identities in the present world, and thus is adding X as a marker at 2 stages of intake. The first of these is updating voluntary demographic questions relating to gender in the agency's online public portal. And this is the area that employees go to when they want to submit inquiries or they want to begin the process to get information about filing a discrimination charge in the workplace. The second place is they're going to be modifying their discrimination form at the EEOC to include the non-binary MX prefix in addition to the Mr. and the Ms. that formerly existed in the list of prefix options. Now, these are important because this is the initial intake stage of the EEOC's operations. So not only are we expecting to see discrimination complaints come in based upon sexual identity and gender identity rather, and sexual orientation, which the Supreme Court and the laws have recently brought into the protections of Title VII, but also the agency is now catching up to make sure that their intake process welcomes and creates a safe place for those types of complaints. So it's different now. It'll be a little bit easier based on the executive decisions to change the way the EEOC operates. Now, this is a package of initiatives, a part of a package of initiatives that have come through from the Biden and Harris administration that are spanning across numerous federal agencies. And a lot of these were announced on the Transgender Day of Visibility that happened at the end of March. These packages of initiatives include reinforcing federal protections for transgender children, improving access to federal services and benefits for transgender Americans, advancing dignity, respect, and self-determination for all transgender people by improving traveler experiences in such ways as streamlining identity verification, upgrading and updating scanning technology to make it less gender specific, and updating the TSA PreCheck and CPB trusted traveler programs to now include the X gender markers. So at ports of entry such as airports and physical ship ports and various other transportation intakes, expect to see where federal agencies are present more of a sensitivity and more of a gender awareness going forward. Additionally, the federal government will be expanding mental health resources in various agencies, particularly targeted at trying to help transgender youth. The issue of gender identity and gender rights, as many may know, has drawn major attention and continuing attention in Walt Disney World inside of the employment sector, which is Florida's largest employer. The leadership at Walt Disney World has taken Walt Disney World Corporation, which is a major entertainment and park property, and also, as I said, the largest employer in Florida. They've chosen to take a stand against the state of Florida's Parental Rights and Education Bill, which is also being known as the Don't Say Gay Bill, depending on different sides of the political spectrum. And the leadership in the Walt Disney World Company, which again is the largest employer, has been known to take a stand against that bill, and that's created a lot of political controversy down in Florida that you'll probably be hearing about on the news. More generally, just to give an overview of what the EEOC does overall, they enforce a number of laws enacted by Congress related to creating equality in the modern U.S. workforce and workplace. An employer's team should always be familiar with various laws providing equality and diversity inside of the workplace, and these include but are not limited to Title VII of the Civil Rights Act of 1964, the Equal Pay Act, the Americans with Disabilities Act, and the Age Discrimination in Employment Act. Meanwhile, to think about this beyond just the federal government sets a floor for equal opportunities in the workplace, but the state and local governments, they set a ceiling. So what you might see is state and local governments reaching even higher to add even more protections for various classifications of people. And these are going to depend on the jurisdiction where an employer's business is either registered, in other words, where they're incorporated, or where they're operating, in other words, where most of their business takes place.
All right, thank you, Jeffrey. With that, we'd like to open up another poll question here. Leon?
Yes, as you've heard, our attorney expert is prepared to answer your questions on employment discrimination on the basis of sexual orientation and gender identity. So make sure to submit those questions when you can in our chat feature here, right here on GoToWebinar. But our poll question is, and hopefully you guys are already answering, do you have an existing policy addressing sexual orientation or gender identity? And your options are yes, we have a workplace policy on sexual orientation and gender identity. Is it no, I have not introduced a policy on sexual orientation or or gender identity? Or is it no, however, I would like more information on how to create and implement a policy that is compliant with protections under Title VII? And I can tell you already, just looking at the results, that they are pretty split among the group. Please go ahead and continue to have your answers roll in, as we would like to get the most accurate information out to all you guys. And I will be closing the poll now. And based on the results, it looks like 40% of you do have some type of policy to address sexual orientation or gender identity, with 33% not having one now, and about 26% open to creating a policy but looking for more information. So thank you all once again.
Yeah, thank you. Let's move on to our next topic. Jeffrey, what can you tell us about workplace gender equality and the wage gap in 2022?
Thank you, Stephanie. That's another hot topic which has followed the just passing Equal Pay Day in March. And this has to do largely with state and local laws, which we talked about in the previous little portion there. The state and local laws are where you're going to see a lot of changes focusing on addressing pay equity. Overall, 2022 has seen a continuation of a trend where state, cities, and other municipalities are enacting or considering what are known as pay transparency laws, which require employers to make broad disclosures about salaries to current and even sometimes prospective employees. One of the municipalities that's doing this is New York City, where after May 15th, it will be an unlawful discriminatory practice under the New York City human rights law for an employer to advertise a job, promotion, or transfer opportunity anywhere within the borders of New York City without stating the lowest to highest salary the employer in good faith believes will exist at the time of the posting. And this will apply to the position in question. Another law on the other side of the country in Colorado, Colorado's Equal Pay for Equal Work Act similarly requires disclosure of hourly or salary compensation and benefits to applicants for jobs. Taking sort of all of this in one place and looking at it as sort of a clearinghouse, the U.S. Department of Labor provides a helpful map on its website tracking to show this development state by state in each of these laws. So there's a website through the USDOL where you can highlight over a state and they'll show you what the latest situation is regarding the equal pay laws. Additionally, Personnel Concepts has much of this information available and tracks it as well. So that's another helpful resource. Something else to consider: in March of 2022, which has just passed, President Biden signed the bill into law that's formally called the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. If you heard about it on the news, you might have heard about that as the change to the Federal Arbitration Act, or the reduction of arbitration. It's something that's changed where the law now bans mandatory arbitration of sexual harassment and sexual assault clauses in employee contracts. So no longer can clauses in employee contracts mandate that sexual assault or sexual harassment claims be forced into arbitration. Rather, the ban permits employees to choose whether they want to go to arbitration on a voluntary basis, instead pursue their sexual assault or sexual harassment claim in a state, federal, or local court. Employers should note overall that arbitration of most other claims, including many civil rights-based claims, remains legal, and it doesn't have any retroactive effect on cases that have already been arbitrated. And employers should always consider discussing with legal counsel whether mandatory arbitration provisions inside of their agreements is a wise decision or not. For both.
Right,
I'm sorry, you got it. Sorry.
You're okay. Thanks so much for touching on those pertinent developments in gender equality. With that, we can move on to our last topic. As the country slowly moves from a pandemic to an endemic stage of COVID-19, the work environment continues to change with it. Along with that, new challenges emerge regarding disabilities and accommodations. Jeffrey, what can you tell us about long COVID designation, accommodations, and COVID-19 policies in 2022?
Thanks again, Stephanie. The Department of Justice, the DOJ, and the Department of Health and Human Services have together issued formal guidance on long COVID. Now, that's kind of its street name. There's other names for it, but long COVID has been designated the general catch-all, and that's a disability that's now recognized under the Americans with Disabilities Act and other laws. This and similar terms are being used to describe conditions where individuals, workers, experience new, returning, or ongoing health problems for longer than 1 month after being infected with a virus that causes COVID-19. Some examples of what you might expect to see in terms of symptomology include lung, kidney, or heart damage, shortness of breath or difficulty breathing, joint or muscle pain, neurological damage, damage to the circulatory system resulting in poor blood flow, lingering emotional illnesses and other mental health conditions such as depression or anxiety, loss of taste or smell, dizziness when standing, headaches, tiredness, or fatigue. Now, to determine if long COVID reaches the level of a disability, the ADA's traditional three-part definition of what a disability is applies in the same way it applies to any other medical condition, and a determination must always be made on a case-by-case, individualized basis. A worker can be an individual with an ADA disability in one of three ways, and for those that have attended Personnel Concepts lectures before, this is a little bit of a refresher, but there's three types of ADA disabilities that are recognized. One of them is an actual disability. That's a disability that an employee brings forward that they indicate substantially affecting one of their or multiple of their daily life functions, which could include their functions in the workplace. There's the record of disability, which is when an employee has a previous documented paper trail of having a disability. And there's the regarded as being an individual with a disability, which is when an employee is known to have a disability, but may actually not have a paper trail and may actually not bring the issue forward themselves. In most of these cases, if a worker indicates that they have a disability, they are eligible for something called a reasonable accommodation under the law from their employer under the ADA, unless the employer would suffer something called an undue hardship, for example, severe damage to its finances or operations in providing that accommodation. The accommodation process involves an in-depth review of job requirements and limitations or performance problems that may be caused by granting the accommodation. Every employee is different, and every employee's brought forward disability has to be analyzed in the context of what the employer can do versus what the employee is asking to need. This is called a discussive process. It can involve several rounds of going back and forth until the final accommodation is sort of chiseled away into something that works. And this always has to be balanced by the employer. What is the accommodation? Is it reasonable? And does it cause undue hardship? So it is a sort of scale that goes on. Along with what we're talking about, the White House recently issued an executive order in response to the COVID-19 pandemic, indicating that the pandemic itself exacerbated already existing severe and pervasive health and social inequalities across the country. For example, people of color, unfortunately, were found to have been more likely to become sick and die from COVID-19 than other Americans. In response, the White House created a task force with purposes including strengthening health data collection, addressing pandemic response to determine if personal protective equipment, tests, vaccines, therapeutics, and resources were allocated equitably, strengthening anti-discrimination policies, and eliminating barriers for the continuing duration of COVID-19 and any future health emergencies which arise. Likewise, employers should themselves take every measure possible to ensure equal treatment of employees affected by health emergencies and be able to respond effectively both to short-term illnesses and long-term disabilities. Finally, there's one final bit of information going on the ADA front. The Department of Justice recently released guidance on how the Americans with Disabilities Act covers people undergoing treatment for drug addiction amid an ongoing national opioid crisis. Specifically, the guidance from the DOJ, addresses how the ADA prohibits discrimination against individuals who are in recovery from opioid use disorder, or OUD, but are not currently using substances.
Thank you so much for that information, Jeff. Lots to consider for reasonable accommodations, both long COVID and for the new accommodation for opioid use disorder. And as you've heard, our attorney expert is prepared to answer your questions on long COVID designation accommodations and other related policies in 2022. Although we would like to get a bit of information from our audience before we move forward. And that will come in the form of a last poll, actually, before we get into the Q&A session. And we want to ask, although long COVID is indeed relatively new, have you yet had an employee request an accommodation for long COVID? So it's either no, you have not. Yes, we've had at least one accommodation request due to a long COVID diagnosis. Or is it C, you're unsure if you've had any such accommodation requests? So go ahead and get those in as soon as possible, and we'll move forward. And don't forget to submit your questions for today's Q&A session. We'll get started in just a few minutes. All right, we're still collecting responses here. And I think we have a clear leader in our response tally. And so I'll go ahead and share with you all. Looks like a 77% said you have not yet had an accommodation request for long COVID, although it's split at 11% each that yes, we've had one, or if you're unsure if you've had one at your particular workplace. So thank you all for participating once again. The information is very useful for personal concepts. We appreciate it.
All right, thank you, Leon. So it's time to move on to today's Q&A session. So to participate in today's Q&A session, I want to encourage everyone in attendance to submit questions by using the Ask Question feature in GoToWebinar. You can also contact our webinar staff by using the chat window. If you'd like to post your questions directly to our guest speaker using your computer or telephone audio, just use that raise hand feature in GoToWebinar, and we'll coordinate with you on your request. We'll do our best to get through the most relevant audience questions throughout today's Q&A session, and all unanswered questions will be submitted to our attorney expert for responses and sent to you via email. With that, let's take a look at our first question. We'll always have them up on the board if you need to reference back to what we're speaking at the time. So our first question here for Jeffrey: how do you show potential candidates that your company is racially diverse when your management might not be?
Okay. That's an interesting question. Obviously, from the employer side, and I work with do labor law and work both on employer and employee side. I can imagine a situation where the employee whose perspective is probably just coming in and seeing top level leadership, HR professionals, perhaps who their boss is going to be, and they're probably doing this in a confined space. I know when I first interviewed at law firms, that's where I was, in a small conference room. So that can be a little tricky. I think that what employers should consider doing is trying to perhaps showcase a little bit of what the full workforce is like through perhaps giving a tour of the floor, or maybe making some introductions to future prospective colleagues in the workplace, even if it's not going to be a guarantee. And prepare the workforce for that so everybody's on their best behavior, but try to give a real presentation of what the actual day-to-day and what the workforce looks like. One way to do that, as I said, is to go around and give a tour. Another way to do that is to consider some literature or possibly some sort of video that shows the overview of the company and what it stands for, and who its people are. That's a really great way to use actual employees. And also it's a good way to get the employees that work there enthusiastic about diversity and to get them involved because they have a chance to participate as well. So again, materials such as anything digital, such as anything printed, and also perhaps a tour, even in advance of hiring somebody, just to show them what it might be. I know a lot of professions might do that a little bit later, but I'd recommend doing it a little bit earlier if you're trying to show the actual diversity of the workplace.
Okay, thanks for answering that for us, Jeffrey. Starting off with a difficult one. We handled it well. Let's see our next question on the board here. Okay.
All right, I got it coming up now. And just a reminder to the audience, I did get a question asking about the slides and the presentation. And everyone that did register will get that via email after the presentation in the next coming days. So just a heads up there. And please continue to submit your questions. I've got one on the board for you now, Steph.
All right, Jeff. How can you communicate to your team that how you speak to colleagues can be perceived as bullying or harassment?
That's another tough one, but I think I have an answer for it, Stephanie. What we see is when we fight on behalf of employers and we do employment litigation claims at the federal level, which is usually where they are in federal court. All the districts and all the federal courts generally look for something called an adverse action. That's the standard that they use when they're doing an analysis of whether or not Title VII or one of the other discriminatory laws was violated. They're looking to see if the employer took an adverse action against the employee. So what they're looking for is, was it materially adverse to the employee's day-to-day workplace operations? Was it something that really negatively impacted their ability to work, and was it for a discriminatory reason? Now, bullying and harassment, that can be for a discriminatory reason because it actually is, or because it's felt that way, or because it's perceived that way, or because it's against a person who's maybe different for some reason or has a protected classification than their other coworkers. So one of the ways to talk to employees to prevent allegations from bullying or harassment from emerging is to consider a few things. One of the ways, a few things actually. First of all, try to address the group when you're disciplining if you can, even if it doesn't apply to everybody. Try to speak to people generally. Try not to single people out, because every person you single out may have a classification or characteristic that makes them think they're being singled out for the wrong reason. So if you can speak to people as a group when trying to do discipline, that's my number one recommendation for trying to talk to people without being perceived as bullying or harassment. Another way to do it is to try to have somebody else there with you and not talk to them alone. Having somebody else there often causes people in leadership positions to temper their behavior a little bit. It also creates a record that you didn't bully and you didn't harass. So try to bring in another member of your team or another member of executive leadership to be there as a second set of ears. Another one that comes to mind often is making sure that before you're at a place where you're doing discipline, you have a strong process in place both for how to do the discipline and also how to review the employee's conduct on a day-to-day basis to make sure they're doing the job properly. One thing I like that's nice and simple is coming up with something that has subjective words and objective criteria, a scale of 1 to 10, a scale of 1 to 100, and some criteria of what you expect for the job, and just periodically review the employee as a regular routine practice, so it's not necessarily necessary for you to take time out, to single them out, to talk to them in a way that could be perceived as bullying and harassment. So just to go over that again, try to talk to everybody in a group as much as possible. If you have to talk to somebody individually, try to bring somebody else in to create a record and to also, moderate your behavior, and try to do the review process in as antiseptic of a way as possible, using criteria, a written record, and something that's routine, so that it doesn't look like it's a singular isolated attack on a person who could perceive it as bullying or harassment.
Great. Thanks for answering that one for us as well, Jeff. Let's just keep going along to the next question here. What is the process of responding to a request for an employee who does not want to return to in-office responsibilities after the pandemic?
We talked about that a little bit earlier in the presentation, assuming that most of us were here. It's going to matter what the reason is for not wanting to come back after the pandemic. That's where you have to start. If a person who's an employee simply says, I have dealt with many of these with my employer clients. If a person doesn't want to come back because they don't want to come back, that's not going to be a protected reason to not come back. And we're beginning to now, as Stephanie said, we're moving towards from the pandemic stage to the endemic stage. As the pandemic begins to, we hope, wind down, there's less local and federal protections in place for the employee who simply doesn't feel comfortable coming to work. Is it a matter of I don't feel comfortable, or is it a matter of a heightened anxiety disorder? As far as that, there's two things to consider. There's long COVID, which we talked about, which is symptoms that continue after COVID that create a disability for a person, which has to be accommodated. And there's also those things that might have had been a situation where they had a disability before and they've been aggravated by the COVID situation without having COVID at all. Again, a good one to go back to is anxiety or depression. Those are two major things that affect people that might make them uncomfortable about coming to the workplace. They may be so anxious about being in a place again that they may not be able to come back. If they cite things to you as an employer that are going to get towards a disability, then you go through the process of documenting, seeing if a reasonable accommodation is possible, looking at it balanced against the hardship it might cause for your business, and then making a decision. Can the accommodation be provided without a hardship being too great? Or can the accommodation not be provided because the hardship is too great? You document that process. You go through several rounds with the employee, discussing with them what they feel they need. I can almost guarantee, based on this question and just knowing people, that what they're probably going to need is to want to work from home. You're going to have to see if that's something that you can accommodate or not. But the important takeaways are you have to know the reason why they don't want to come back to the office, and it has to be related in some way to some sort of ADA protected disability if they're going to have any sort of ADA process to check their disability to see if it can be accommodated, to see if a hardship exists. If they simply don't want to come back, then that's job abandonment, and that's a different situation.
Great. Thanks for that in-depth answer again. Okay, let's move on to the next question here. I understand it is determined case by case. However, what reasonable accommodations can employers typically expect to grant related to long COVID diagnosis and subsequent accommodation requests?
Well, I appreciate that the questions are a little related, so we can stay on the same topic. I think that the types of accommodations that we're going to see, the big one is going to be those people who cited disability as a reason to want to continue to work remotely. There's many examples of that. I'm sure employers on the other side of this presentation are nodding their heads, and maybe they've had a few of those in all different sectors. But it's going to depend on what the job is. If you do a job that's mostly computer-based and technical, professional creative, you may be able to stay home. But if you do a job that's more manual and you work on the floor of a factory or warehouse, you may not be able to stay home. Those processes aren't automated so readily. So what we can expect to see is a round of people who want to stay home because they were home before and they worked, from home during COVID, and they teleworked. There's a lot of resources that people have become accustomed with because of that, such as Zoom and various other things. So we expect to see that. Inside of the workplace, for those that are coming in, we expect within the confines of the long COVID type symptoms, we expect to see people indicate that they have a difficult time standing or sitting for long periods of time. That has to do with the blood flow issue. For some people, it has to do with the breathing issue. COVID was a lung affecting disease, among other things. You may expect to see people ask for time to take doctor's appointments. That would probably apply to your people with mental health issues, the depression or the anxiety. They may need to leave during a work day at some point to go talk to a counselor to be able to integrate back into the workforce. And you may see people ask to switch from jobs that were more physical to jobs that are less physical. Again, that's going to go back into the circulation, the breathing, and any physical effects that are left over from COVID-19. People may feel depleted compared to before. Fatigue is a major one. So those are the types of adjustments that I've seen. Those are the types of adjustments that we expect to keep seeing. Remember that this disease, the symptoms, just to go back, the symptoms we talk about as part of long COVID, most of those on their own are disabilities. Long COVID is just the way that we're getting there now. So if somebody says long COVID, there's probably something underlying it, like a mental health condition or a physical ailment, that as an employer, you've probably accommodated before, or at least thought about how you might have to accommodate it someday. So long COVID isn't really creating any kind of new needs. It's just bringing a lot of things into the disability category that might have otherwise come up other ways. The symptoms are pretty much the same as things we've seen.
All right, thanks, Jeff. Okay, let's get another question here. What does the employee have to do to prove long COVID?
Well, the employer has the right to request reasonable documentation of long COVID. So that's pretty much your proof stage. It's going to usually begin with an employee saying they have some symptoms left over from having COVID or that have returned. That's going to be the first step as the employee brings to you the disability. You as the employer can take the employee at their word if you choose to. If you prefer to go to the documentation stage, you are allowed to request reasonable documentation from the employee's physician. At that point, there'll probably be some sort of HIPAA type release that gets signed that allows the doctor to communicate this information with you. And then the employee will ask the doctor to communicate whether or not they have a diagnosis of long COVID. It's possible that if the doctor's very involved, the doctor may go as far as to suggest the accommodation. Sometimes that happens, sometimes it doesn't. But reasonable request of documentation is always permitted under the ADA discussion process. So the doctor could become involved as long as the employee is contacted first and they grant their permission.
It's good to know what they can expect there. All right, let's see another question on the board. How do you change a company's culture to show equality and a positive environment?
Hire good consultants. No, that's part of it. How do you change the culture? Well, I'd like to assume the culture is not bad to begin with, but could just be made better. Could be made more of an aware culture. I think education is important. I think that Personnel Concepts as a private entity and the EEOC as a public available resource have a lot of information about how to educate the workforce. I think it's important to have trainings, kind of like the one we're having today, where people can talk about these issues and they can learn sort of what the aware workplace terminology is that's going on these days, so they can use the right terms and not offend anybody. As far as showing it, you can try to implement policies that draw from diverse groups of people. You can think about where you reach out to and how you advertise. The internet's a great equalizer. Depending on the type of job you have, if you're still using physical resources, you can try to locate postings of jobs in places where you can bring in a more diverse workforce. One thing I like to think about is police departments. I think that most people today are probably not on this call that run police departments, but it's a good example. Police have gotten into a lot of trouble in various places because they haven't had representative police forces that look like the communities they serve. One way you can accomplish that is by going over to the next town where maybe people do look more like the community, or going to the community's grocery store or whatever it is and posting up an application and trying to target a specific area. Those people will come to you. That's one way to do it. As we said, showcasing some of the diversity and some of the showcasing employees, talking about, well, just showing them, showing them and talking about some of their things that don't necessarily bring out the protected characteristics in a discriminatory way, but maybe, for instance, focusing on some of their other things. For example, if you profile your employees and your employees come from different areas, they look different physically, they have different educational backgrounds, they have different skills, that's going to bring the conversation of diversity into the public arena for your employer, without actually saying, oh, this person is Black or this person is Latinx. It's going to be necessary to say that. People are going to see that, and they're going to see also that they have diversity based on their geography, based upon their experiences. So there's ways to do it without being discriminatory, and still get that across. Of course, you can look at the way that many types of businesses and industries do this. Colleges are great at showcasing diversity. Many large businesses are. As far as changing the culture, I think it's definitely about training overall, and it's about reinforcing with positive examples. And training has to be, because as we've learned today, the language of what equality and inclusivity is, it's a changing language. It's an evolving language. So we've been doing this for a while, myself in Personnel Concepts, the gender identity and sexual orientation issue. That's really only become a major thing in the last, from a legal standpoint, it's only become legally enforceable at the federal level in the last year or so, and that's changed the culture. So you have to be aware of it, and that's where the education is important. And then again, showcase it.
Great. Thanks, Jeffrey, for that guidance. Okay, our next question on the board here. How do you tactfully explain to leadership the importance of following EEOC hiring practices when selecting candidates?
I think the best way to do that is to probably try to draw their attention to the EEOC's readily available resources. One thing the EEOC is great with, that I give to my employer clients all the time, is fact sheets. They've got fact sheets on exempt versus non-exempt employees. They've got fact sheets on their own complaint processes. They've got fact sheets at the EEOC that are numbered, that cover almost every topic. And if you don't want to be sort of talking to your employer, who's your boss, or your leadership of the employer, if you don't want to feel like you're talking to them in a way that sounds like you're kind of disciplining them, or maybe stepping outside of your role, point them to the resources. Send an email with the appropriate links to the hiring process part of that, and then they can follow the EEOC's guidance like that. If you already work there, unless you're in HR, it may not seem like something you should be bringing to their attention, but it's great to just share general information about what's available out there. And you could always also phrase it in the way that, I saw this interesting thing from the EEOC. It seems like the latest update. Just wanted to share it with you. That makes you look like a great employee who's trying to help the company, instead of saying, for example, are you following the EEOC's practices the right way? Here they are. It's all in the way you communicate. If you communicate tactfully, like you noted in the question, dear audience member, if you communicate tactfully, then you can say almost anything. Try to remember that the purpose of what you're doing is to try to help the company, which helps them, which ultimately helps you. And try to let them know that you're directing them towards readily available information, which is out there, which means it exists and it's enforceable, and just wanted to make them aware of it. And that also protects you, because if you have that role, then you're doing your job by bringing it to their attention. If you're in HR, you're in a part of the leadership team, you're doing your job, and by sending them something in writing, you're showing that you did your job.
All right, thanks, Jeff. All right, let's see our next question on the board here. My understanding is that diversity and inclusion training is not required by law. Do you recommend it? What are the benefits from a legal standpoint?
I do recommend it. There's one practical benefit that's a major one, and then there's, like we said, the legal benefit, which is a little bit more technical. The practical benefit is that diversity and inclusion training improves the overall environment of the workplace. It makes it the opposite of what legally we call a hostile workplace. Inclusion and diversity changes how people treat each other. It changes how people speak to each other. It changes how people speak to outsiders. And that can improve the culture of your workplace and make it more productive overall, I believe. And I think many agree. From a legal standpoint, providing training is something that gets raised as an affirmative defense when you end up with complaints that fall under Title VII or any of the other labor and employment laws at the federal level or their state equivalents. So what happens is when somebody brings forward a lawsuit as a plaintiff and says they were discriminated against, one of the things that an employer can do when they're providing their defense is they can show that they had a workplace training policy that talked about diversity, inclusion, non-harassment, and those various types of things, education on the laws. If they put forward the training, then they can use that as an affirmative defense, or they could use it as a fact as they're trying to defend. As the litigation proceeds, that fact gets weighed against whatever the claim of the employee is. And if it's strongly shown that they had a strong policy in place of this type of training, then what ends up happening is the one bad apple who might have been the employee who wasn't paying attention to that training, they might be the person who gets in trouble and the employer might be relieved of some responsibility. Perhaps it might be possible to show that they went above and beyond the scope of their way they're supposed to behave, employee, and you might be able to sort of wiggle them out from you, get rid of them, perhaps terminate them, and then leave them on their own with the lawsuit while you as an employer have an affirmative defense. So that's one of the ways that you do it. It's an affirmative defense, and that's why it's worth the investment, because even though it seems like it might take time and cost money to do something like train your employees, it's going to cost a lot more money if you lose a successive series of discrimination lawsuits. So it's much better to have the training in place and have a ready to go canned defense in place, as opposed to having no training and then having to try to figure it out backwards. Training and documentation of training is a great affirmative defense. It will work for employers, and it will definitely save them time and money in litigation.
Great, thanks, Jeff. And Personnel Concepts, we do have a workplace diversity and inclusion training for employees, just to note. So if you're interested, you can find that on our website as well. But let's move on to the next question here on the board. You spoke about the New York City salary transparency law, which requires businesses with 5 or more employees post a good faith minimum and maximum salary and job openings. Do you believe we'll see a trend to this in other cities and states?
New York City's progressive. They're known to be liberal in terms of their laws and in terms of their politics, generally speaking. So they in California tend to lead the pack on these types of laws. However, we noted that there was also a similar law in Colorado, which is another state in a different place. There are laws like this cropping up all over the country. It seems to be the trend. Pay transparency. We may be familiar with it, all of us as regular folks in the labor and employment world and as employers and employees, because the postings of jobs that go online on job boards often have the ranges included. That's sort of a proactive response, a prophylactic response to what's happening in the law. It's been going on with a lot of employers anyway. I would expect, yes, to see this trend, but I would say that if the law gets passed in New York City that's related to labor and employment, it hasn't taken effect everywhere yet. New York City and again, New York City, New York State, and California, they tend to be first. They tend to lead trends, but they tend to be first, and it tends to take other areas time to catch up. As far as other cities and states, how that works, states definitely might be possible. New York City, as a local entity, you would not probably expect to see laws like this be created by anything other than large municipalities. I said municipalities, but you're not going to see a very small municipality in the Midwest have a labor law. Anything that's under a certain size is not going to pass these kinds of laws. They don't, small towns don't deal with these kinds of things. So expect to check, if you're in a big city, expect to check your big city's laws. I guess big city, maybe over 50,000 people. Big cities would have their own laws like this. Again, states would have their own laws. And it's possible that eventually the federal government might catch up. But I definitely think it's a trend that we're heading towards. I think it's positive because I think it creates more transparency, obviously transparency, but it makes it better for the employer because people come in kind of knowing what to expect. And that's one less thing you can have to haggle about when you're going through the application and interview process. So it's one more thing that's out there on the table. And remember that as long as it's reasonable, it can also be a range, which gives you as the employer some discretion. It can be a range and it can be a reasonable range. And as jobs go higher in value to the company, usually the pay is higher and then the range can become a little bit bigger. If you're up in the 6 figures, the range can be larger than it can be at lower levels. And that gives you an opportunity to, have some discretion and choose from a more diverse workforce. It's not that tough of a law to follow. And I think the benefits of it probably outweigh the burdens. Remember, these things have to get through various legislatures with people that were voted in. So some people must think it's a good idea because they voted for their leaders. So I think it's probably a trend, and I think it probably has some benefits that employers should think about and check your local laws.
Right. Thanks, Jeff. Always a good idea. Check the local laws. All right. Let's see our next question here. With the new laws on pay transparency, when is it legal to not disclose employee wages to other employees?
That's a great question. I almost want to draw it on a piece of paper. There's probably still NDAs out there that employers, because I write them, I'm sure other people write them too. There's NDAs out there where employers don't want the employees to tell each other what they're making because it creates discord in the workplace, and that's perfectly fine. It's not the communication between employees laterally, and it's not the communication between employers and other employees about what Ms. Jones is making. It's the communication about what the role offers. So just to see if I can clear that up a little bit, hopefully it was not too unclear. They have to post the pay transparency for what the roles range is, generally speaking, in places where these laws exist. So it has to be this number to this number, salary minimum to salary maximum. That doesn't mean you have to disclose what all of your employees are actually making all at once to everybody. There's a few places where that's a little different. Public sector, some of the stuff is audited and put online depending on what state you're in. But generally speaking, you don't have to go about disclosing the current salaries of employees to the entire workforce. That's not what this law is about. They're looking for it to be posted for people at places where jobs are being offered, so people know what they're coming into and so that they have a little bit more self-determination as to whether or not they want the job. So that's the thing. And again, restricting employees from communicating with each other about their salaries, which I think a lot of employers want to do, doing that in an NDA is still allowable.
All right. Thanks, Jeff. Let's see if we can get another question here. We still have less than 10 minutes, but we can still get questions in. If they're not answered, we'll make sure to forward them to Jeff and he'll still get them emailed out to everyone.
Yeah.
All right. Our
Yes,
next.
please. Yeah, I was going to say yes. Please continue to submit your questions. Like you said, we'll answer them on the back end. We got a few additional questions on long COVID, so I'll go ahead and send those over to you.
All right. Thanks. So the question is there a time restriction for the duration of accommodations, assuming for long COVID?
No, there's not going to be any time restriction for a disability accommodation. The way the disability accommodations work is the accommodation should continue for as long as the disability remains. There are, of course, cures. There are times when disabilities go away, and that's possible, and that's part of the process. But unless the disability disappears, these long COVID hasn't been around long enough to know, right? But the types of things that are part of long COVID, as I said, they've existed before in other ways: depression, anxiety, shortness of breath. There's been diseases before, those diseases and versions of those diseases that have lasted people's entire lifetimes while they work, and their accommodation has lasted their entire lifetime. The law itself does not set a timestamp on when the disability accommodation expires. It goes on as long as the disability exists and the employee continues to need the accommodation.
All right. Thanks, Jeff.
Oh,
Okay.
I'm sorry, Stephanie. I'm so sorry. I just came to me. What could change is the undue hardship calculus. That could change. I mean, if at some point it became an undue hardship to continue to accommodate the employee with their disability for some reason, for instance, if the business changed its complete operational methods, that's possible. If the employee brought a suit, it might be looked at, to see if there was any bad faith. But if the employer's situation changes, they do have the right to reassess on the hardship accommodation balance. It just came to me. I know businesses change sometimes what they do or how they operate.
Yeah, it's a good additional note for the employers out there. All right. Let's see our next question on the board here. What are the points to consider for employers that are looking to treat employees equally?
Employees should try not to. We've identified some of the classifications of persons who are protected: people with disabilities, people with what they in the law they call mutable characteristics. So anybody with race, national origin, religion, gender, sexual orientation, gender identity. Those are a little bit different than gender. Pregnancy. All of those are protected classifications. It's easy to find out what the list of those are. Most people are aware of them. If you're looking to treat employees equally and be known as a company that does so, you have to make sure that the actions you take as an employer don't do one of two things. They can't discriminate against those people directly. So certainly you would not want to have anything where you acted against them, materially adversely against them as an employee because of one of those protected characteristics. That's the first test. And the second one is not indirectly, or what they call trying to think of a good way to not use. I use a lot of legal language, but it's called invidious discrimination. It's called, it's like saying implied discrimination. You may not be saying to a person, "I'm demoting you because you're female," or "I'm demoting you because you're Hispanic." You might not be saying that, but if it's found out that that is part of the calculus somehow, or that weighed into the decision to take a material adverse action against a person, that's an issue too. So the two things to look for: never overt discrimination based on a protected classification. That's number one. And then number two, nothing that could be perceived as being implied. How do you do that on a practical level? You try to treat everybody equally without consideration for any of those characteristics. And you try to look for the things that could be perceived or implied as being based on that. It's going to be helpful, I think, if I give an example or two before we leave this question. One thing that comes up all the time in discrimination cases and modern ones is when there's workplace dress code. The dress code has to be reasonably related to the job as required. If a person works in a site with a lot of heavy machinery, in a construction or manufacturing type situation, there may be certain reasonable restrictions on how a person dresses. But if a person sits in an office and works on a computer and they wear religious garb that perhaps is long and flowing, or they have a hairstyle that's long and flowing, if that's based upon something that's a protected characteristic and there's no related reason to the job to restrict it, you want to be careful not to create a policy that restricts it. You shouldn't restrict it, for example, because you have a client who finds it to be distasteful, or a client who finds it to be surprising, or whatever negative reason a client might not like it. It can't be. If it's protected characteristic, they have to be allowed to go. There has to be a reason related to the job and what's necessary if you're going to do that. And it has to also be applicable to everyone. So, everyone can't wear long flowing clothes. It can't be that the religious garb is restricted, but a person's allowed to come in tomorrow wearing a band t-shirt that runs down to their knees just because it's not religious. It has to be applicable to everybody. So those are some of the things to think about. I know it's a broad question. I'm giving sort of a broad answer, but it's those types of things to consider. An equal application to all always, and always related to job. It has to be related to job. Some of the stuff that's gotten by with the dress code restrictions I'm talking about, some of the major cases, restricting people's religious headdresses when they have to wear helmets, that's come up. Again, restricting long flowing clothing when people work in manufacturing, that's come up. Those types of things have passed, but generally speaking, it has to be very, very important to the job.
Right, those are definitely some good points to consider. I think we have time for about one more question before we go into our wrap up here. Again, continue to submit your questions, though. If they don't get answered during this time, they will be answered by Jeff via email. All right, so our last question on the board.
Actually, Jeff, if we could get through this one fast, I do have one more pressing question that'll be after this one. Sorry, Steph. It's just it's a little bit long, so we're condensing it so the audience could easily understand.
I'm here, guys. Let's do it.
All right.
One
Is
more
there an
after this.
end? So we'll go with this one quickly. Is there an end date to consider long COVID or COVID-related symptoms as disabilities, or is it here to stay?
I think it's safe to say that an entire generation was probably affected by it, entire generation of the workforce, and I think it's more likely that we'll see more of it than less of it in the future. This is not the first. This is not the first disaster or emergency that we've seen in most of our lifetimes that's had long-term effects. I work in the New York City, New Jersey metro area, and I talked previously about the Zydrogas disease, one of the many diseases that came out of 9/11. In this area of the world, we're experiencing 9/11 related illnesses that have stretched on for the duration of people's lifetimes. That was one day, one terrible day, and one terrible set of events. But the illnesses that came out of it, they lasted a long time. Expect similar from the pandemic. A generation of people was affected by this. Some of them have long-term health effects, and for as long as problems are around, COVID will be remembered, not fondly, but it'll be remembered, and there'll probably be some effects of it left over.
All right, thanks for quickly answering that one. Okay, let's see our next question on the board, please, Leon. Drum roll. Anticipation here. Okay, let's see. Our last question. I have seniority in my department, and the most educated and experienced, I've trained someone else. Someone else with less experience got promoted before me because they have a personal relationship with the manager. Am I able to take legal action?
I like this employee. They're duly confident. It's good to know where you stand in the place. Someone else with less experience was promoted before. Well, as a lawyer, so I'm here with you. So as a lawyer, I'm curious about the statement because they have a personal relationship with the manager. I'm curious how you could evidence that. That's a question. You know, I know you're saying it. I wonder if that's in writing or if that's indicated somewhere or if that's manifest in some kind of way. I don't say that to challenge you or to knock you down. I say that because that's what you'd have to prove. And then on top of it, you would probably have to prove that there was some sort of discrimination that went on against you and in favor of them. If you're more qualified for the job by all these criteria, you're being more educated, more experienced, and someone else was promoted over you, unless there's a discriminatory reason for that, that's still acceptable. I mean, there's only two types of laws that protect workers in the work. Well, there's several types, but there's two major buckets of laws that protect workers in the workforce. There's constitutional laws, which are the ones we've talked about today, the Title VII of the Civil Rights Act, the various laws that have come out of that, pregnancy, age, disability, those types of laws. Those are the constitutional protections. Union laws are another one. Those are kind of constitutional. If you're in a union, you have some grounds. Beyond that, all you have is contract. What is your promotion right? What is your schedule if you have an employment contract? What is the employer guaranteed to do as far as review, consideration, and promotion? You have that to turn to. Those are your bases of law, the constitutional bucket and the contractual bucket. That has to be available to you in order to bring a claim legally. As far as the personal relationship, you'd have to be able to prove that that's why the other person got promoted. But more importantly, you have to prove why you didn't get promoted. It would have to be because of a discriminatory reason or a contractual breach. Otherwise, the employment situation is largely at will. And you know, just because they have a personal relationship with the manager, I'm not sure that's enough. You'd need to be able to reach into one of those other legal areas, constitutional or contractual, to try to bring a claim forward.
Hey, thanks, Jeff, for answering that. That one was a mouthful there. So, unfortunately, we have run out of time. All unanswered questions will be forwarded to Jeffrey via email, and his responses will be sent to all attendees in the coming days. Thanks to everyone who submitted their question for today's session, and thanks to Jeffrey for taking that time to answer them. Please stay tuned here so we can go over the key takeaways, something you might have missed.
Yes, yes, and we had one more poll in the schedule, but I think it's more important that we get straight to the takeaway so anyone that has to leave at the top of the hour can get that important information. So Jeff, if you don't mind, can you get us started with the key takeaways on discrimination on the basis of sexual orientation and gender identity?
Absolutely, Leon. So here's what we talked about today. These are the key takeaways on sexual orientation and gender identity in 2022. The EEOC has announced that the binary construction of gender as either exclusively male or exclusively female no longer applies to reflect the full range of gender identities. Going forward, they're going to use the X marker as an additional marker at various stages of intake. So now you'll see male, female, and X. And in terms of the other forms, see Mr., Ms., and MX. Number two, the EEOC changes are part of a package of initiatives rolling out from the Biden-Harris administration that span across numerous federal executive agencies, and they've been announced in recent months. Number three, an employer's team should always familiarize themselves and continue to update their familiarity with the various laws promoting an equal and diverse workforce. And we had great questions from the audience about how to actually do that today.
All right, thank you, Jeff. Can you also remind us of the gender equality and wage gap takeaways?
You bet, Stephanie. Overall, 2022 has seen a continuation of a trend we feel is continuing on, where cities and other municipalities are enacting or considering pay transparency laws. Additionally, President Biden has signed into law the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, and that affects whether or not, it affects employers being no longer able to add arbitration forcing clauses into contracts with employees and independent contractors when the topic is sexual harassment or sexual assault. They now have the option of going to litigation or going to arbitration.
Thanks again, Jeff. And finally, please bring us home with long COVID, reasonable accommodations, and other related policies in 2022.
Bringing us home, Leon. Long COVID is now recognized as a disability under the EEOC and under the ADA. In most cases, if a worker indicates they have a disability, whether it be long COVID or otherwise, they're eligible for reasonable accommodation, taking into the undue burden balance. Employers should take heed of the national response now underway to ensure a quality and health emergency response, and they should examine their own policies accordingly because the government may come knocking on their door and asking them questions about it. Finally, the DOJ has recently released guidance on how Americans with disabilities, the Americans with Disabilities Act, I should say, now has also been expanded to cover people undergoing treatment for opioid use disorder or OUD.
All right, Jeff, thanks so much for reviewing that for us. Before we end today's session, I'd like to remind everyone that all attendees will receive a follow-up email with a certificate as proof of attendance to today's webinar. We enjoy hosting webinars for our valued customers, and as such, would really appreciate your feedback. Please stick around a couple of minutes as a brief survey will open for you to rate what you saw and heard today.
Yes, and this concludes today's webinar. Thank you for attending our presentation. We hope you enjoyed and benefited from today's Ask an Attorney Creating Equality in Today's Workplace webinar session. Thanks again to Jeffrey for participating as our expert panelist. We look forward to continuing on working with you on future presentations. Thanks again, Jeff. And if you enjoyed today's webinar, we invite you to view past webinars on demand at the link provided on the screen. Also, please subscribe to Personnel Concepts podcast, the labor law report for biweekly employment law updates hosted by myself and Stephanie Balecki. To all of our attendees, thank you for choosing Personnel Concepts as your provider of workplace compliance solutions, and have a good afternoon, everyone.